on time. We're going to be respectful of that. Thankfully, we're getting this all on video, so we'll be able to make it available to those who couldn't be here. My name is John Acosta. Most of the row in the back knows me. And some of you in the front. I'm president of the local, and I'm really honored to be able to be part of this conversation with my fellow panelists, who will introduce themselves. But this is something that we've had in the works for some months, working with Actors Fund and trying to figure out the right setting. We have staff here that are, really interested in, understanding this issue and how the union can respond and be supportive. And we have other unions, I believe, represented here, and members, rank and file members, who also are obviously very concerned and interested in the issue. So with that, I want to introduce or hand it off to my fellow panelists.
Okay. Good evening, everybody. It's good to see you here. My name is Dana Martinez, and I am outside counsel for Local 47. I've been a union side labor lawyer for about 17 years. Before that, I was a union organizer and an activist in college. And part of my practice does cover representing unions as an employer and advising unions on employment issues, including labor issues.
Great. And my name is Tina Hokum. I'm a licensed clinical social worker. Hi, welcome. And we just thank you to Local 47 for including us in this conversation and being on the panel. And we'll kick off our presentation. The Actors Fund, for some of you that may not know, is a national not-for-profit. So despite our name, we help everyone in entertainment, including musicians. And our mission is to really help foster resiliency and stability for people working in the creative community and to help them along their journey. 2 years ago, the Actors Fund began working with unions and guilds and associations on this issue of sexual harassment. And we began helping unions to begin to understand themselves and help our community begin to understand the issue. Before we get going, everybody has a card on their chair. And as we continue down, we're hoping that people can write questions that they may have as we go along. We're going to do the first part as a formal presentation and begin to gather a common knowledge and understanding of what this issue relates to, and then we'll have time for questions and answers at the end. Before we get going, I want everyone to sort of take a moment and on your card, if you can, to rate yourself on what you think you know about this information on a scale from 1 to 5, 5 being something you have expert knowledge in, a lot of knowledge in, right? That'd be a 5 to 1, something that's brand new. And so where do you fall on this topic of sexual harassment or harassment in general? And our hope, our intention, is that throughout the course of this evening, that rating would go up. We're not going to ask anybody to disclose the rating at the beginning of the event, but that is our intention. Okay? So let's get going. This is our agenda. We are going to cover the challenges and effects. We're going to go into some definitions of what is sexual harassment, what is it not. We are going to talk about ways to respond to harassment in the workplace environment and things you can do. We're going to talk about helping one another and talk about our creative community and how we can work together to shift our culture. And lastly, we're going to make sure that everybody walks away with a clear understanding of resources in the community and how to utilize your union if you, in fact, begin to experience some of these things for yourself. Okay? So to start our conversation, it's important to have context. So what is harassment? Why sexual harassment? Why now? Why are we hearing about sexual harassment every time we turn on the news? Has sexual harassment increased? Is it something that's always been part of our workplace environment? And so to sort of help us build that context, in 2015, the United States Equal Employment Opportunity Commission, the EEOC, which we'll talk more about, which is a bipartisan group that's working on the federal level, created a task force that conducted a study of harassment in the workplace. And 16 people came together for 18 months to do a deep dive in what is happening in this issue in the United States of America in our work environment. They talked to different professions. They did a deep dive in the literature. They talked to people who had reported claims, talked to witnesses. They reviewed testimony. And at the end of it, what they were able to commission is a report that really highlighted the status of harassment, and specifically sexual harassment, in our communities and what the impact is to individuals, the workforce, and our organizations and businesses. And this is what they found. That as many as 1 out of 3 of women, right, have experienced sexual harassment in the workplace. So if we were to do a small sample of our group here, right, 1, 2, 3, 1, 2, 3, 1, 2, 3, we would see that that's a pretty significant number just in our small group right here, right? In addition, what they found out is that 71% of all sexual harassment cases go underreported. So another way to look at that is that roughly 3 out of 4 of us, 3 out of 4 individuals who experience harassment never talked to their supervisor, never approached their union representative, their business rep, never approached their supervisor, and even discussed that there was inappropriate conduct happening. Employees who experienced harassment failed to report their harassing behavior or to file a complaint, and they cited these reasons. That there was a fear that the claim was not going to be believed. There was a disbelief in the claim that was even happening, right? They also found out that most people feel that nothing was going to happen, right? If they did report it, nobody was going to do anything about it. They also feared that they themselves would be blamed, that they would be focused as somebody who induced the harassment. It was their fault that they were being harassed. And most importantly, that they felt that there was going to be some kind of social or professional retaliation that was going to negatively infect them or their career. Some of the other findings that they cited was that this fear of retaliation was actually based in evidence. It was true. And that 75% of all people that do report have some consequence, some retaliation that they experienced from reporting. The other important facts was that harassment, and particularly sexual harassment, can really thrive in high levels of industries where there's high levels of male dominance, which is the entertainment industry, right, which is the music industry. So our community is particularly vulnerable in this way. And that filing a complaint is the least used option for an individual to think about utilizing. And those reasons were really based and that they felt that there were other things they should be doing instead. They should avoid the harasser altogether. They should endure the behavior. They should attempt to ignore it or forget about it, or there was a sense that they always needed to downplay the gravity of the impact for them and their work environment. So to sort of funnel down, right, to us, right, that's sort of the broader scope, to funnel down to the entertainment industry and particularly the music industry, it's important to highlight the great things about the music industry, the music community, right? There are wonderful work environments, work endeavors, right? A lot of creativity, but the diverse and the varied opportunity of our work environments can make things like workplace environment, can make work culture and policies and procedures very hard to begin to understand because of the nature of the work in the industry. And we're going to talk about some of these because it's important to know as you move around in your career. So the challenges unique to the industry are we have multiple employers, right? It's not different than a traditional work setting. Most people in the industry have multiple employers throughout a year. Some people don't even know who they're actually working for, right? They get a phone call, they're told to show up at 8 o'clock, they go show up at 8 o'clock, they do their gig, the check's written, and they move on to the next thing. So not knowing who the employer is, not knowing whose responsibility it is to create that safe and work environment can often be some of the disconnect that 1099, sporadic income workers can begin to feel in where do we have our power, right? If we did feel that something was wrong, how and what should we be doing? Right? We travel together. We work in tight quarters. We can or might change our clothes if we're in the pit or in the set. We rely a lot on informal networking to gain our jobs. So we often find ourselves going out to drinks, meeting at bars, meeting in all of these places to procure more work, which then begins to make the boundaries of the world of work, or can make the boundaries of the world of work, begin to feel very curious, very unorthodox, right? And lastly, which I know you all know more than me, is that there's a lot of power dynamics. And power dynamics are a very important and real part of the issue around sexual harassment. So we're going to take a second to look at those. So legitimate power is what everyone can know, right? Legitimate power is a person, it's a position of power over you, right? This is the more traditional ways that we think of a manager and a line staff worker, right? This person has legitimate power over what happens to you in your world of work experience, right? Expert power, I think particularly in the creative communities, there's a lot of people that gain expertise in what they do. And that expertise makes them want to be worked with, maybe makes them want to be referred by. And that expert power within your craft can give you a lot of options of behavior, perhaps, right? Reverent power. Reverent power is somebody that's revered. Their personality, their craft, somebody wants to work with them because of their reputation, because of the prestige that they hold power over you. And then decision-making power. This is the power that hires us, right? There's lots of people that may not have a legitimate hierarchical structure over our work environment, but are referring us and are hiring us into our jobs. And it becomes very important how we handle those power dynamics if we feel that we actually are going to work under their refrain. So all of that was just to set a context and a frame for us to understand why we're having the conversation, why we're here, right? Why it's important that we in the entertainment industry lean into this topic, which can sometimes be challenging, and begin to define and understand it. So we're going to turn to Dana and have her begin talking and walking us through some of the legal definitions of what is harassment and what it's not.
Thank you. And before I get into the details, I just wanted to put my presentation in perspective. I'm trying not to be over legalistic here, and the information I'm giving you is to provide you the broad brushstrokes about the law, so that you have some additional tools of what to look for, what to identify, how to identify it, and what context to put it in. So I will present this information, and if it gets confusing or overly legalistic, we have the question and answer portion afterwards. So the first slide you're seeing is harassment and discrimination. So the basis of what we're talking about today comes from the Civil Rights Act of 1964, which is Title VII. And Title VII made it unlawful to discriminate or harass individuals based on a protected category. All of you are probably familiar with protected categories such as race, gender, disability, military status, ethnicity. All of those are examples of protected categories where it makes it unlawful for someone to discriminate against you or to treat you differently based on that category. And so this law provides the basis of the unlawful conduct that we're going to be talking about today. So let's talk about who is protected. We're going to talk about harassment and discrimination in the workplace. So who's protected? Employees are protected, but job applicants are also protected. Interns, whether they're paid or unpaid, they're also protected. Volunteers are protected. And I should mention auditions. So it's the same thing as an applicant. When you're auditioning for something, you are also protected by the law. Oh, I forgot to mention this is also relevant to you. Independent contractors are also protected under the law. Okay, so we're going to talk about how a court will review evidence and how a court will try and understand whether or not harassment occurred. And the court will look at it from two perspectives. From the personal perspective of the victim, that is the subjective standard. How did the victim feel? Did the victim feel harassed herself or himself? The court will also look to look at the facts in an objective lens, which is how would a reasonable person in the victim's position feel? We will talk a little bit more about the reasonable victim standard. It's not a reasonable person standard. So if I am a woman and I'm victimized, the court will review the evidence from a reasonable woman situation who's similar to me. Which I think we just, we probably just reviewed that. Okay. So what is sexual harassment? Sexual harassment is a form of discrimination that's based on your sex. And it's not just your sex, female and male. It's also based on gender, gender identity, sexual orientation, gender expression, and also conditions, if you will, that are unique to your gender, such as being pregnant, such as nursing. All of those categories are protected when we talk about the law protecting you from sexual harassment. It's based on your sex, as just defined. It also, a part of the definition is that members of one sex are exposed to disadvantaged terms or conditions of employment to which other members of the other sex are not exposed. So if it's happening to women and not to men, that is an example that you are being treated differently because of your sex. It does not need to be motivated by sexual desire. Again, it's just treating you differently because of your sex. There are certain forms that it comes in. It's not just in one form. We can identify sexual harassment and discrimination through conduct that is visual. So such conduct is leering, making sexual gestures, displaying sexually suggestive objects or pictures, cartoon. So it's the workplace environment. If there's a lot of pictures, a lot of pornography going on, or if you're a supervisor at his desk constantly is viewing pornography and you're seated right next to him and you're subjected to that all the time. This is a visual display of harassment. Verbal displays of harassment, derogatory comments, slurs or jokes, verbal abuse, graphic comments, sexually degrading words, repeated romantic overtures. And then, of course, physical. Physical harassment, touching, assaulting, even impeding or blocking somebody if they want to get somewhere. All of those are examples of different forms that we could find sexual harassment and discrimination. Yeah, I think I covered that. So let's talk about the two forms of sexual harassment, quid pro quo and hostile work environment. These are probably terms you've heard before. First, let's talk about quid pro quo. Quid pro quo, I have to say that really slowly, is this for that. I will give you the promotion that you've been wanting if you have sex with me. That is what the quid pro quo is. In order for it to be actionable or unlawful, the person who is making the quid pro quo statement must have apparent or actual authority to extort sexual considerations. So it's a supervisor, a manager, somebody who has the power to fulfill the promise, if you will. I think we are taking questions at the end.
Yeah.
Okay, great. It does not have to be express. It could be actual or apparent authority in order to be able to effectuate whatever the promise is or the grant of benefit. So the elements to look for. First of all, or the elements, necessary to prove unlawful quid pro quo sexual harassment. Unwelcome sexual advances. The acquiescence to this is not fatal. So long as the victim has in some way indicated that the advancements are unwelcome. A victim may understand that unless she sleeps with her supervisor, she's going to be fired. She has bills to pay, she could be a single mom. There are conditions that may compel her to engage in the offer of sexual conduct. That does not mean that she no longer has a claim just because she engaged in sex with this person. It must be based upon sex, her sex or his sex. We'll talk about that in a little bit. And
Gender.
Well, there's a difference, right? So sex includes more than just gender. No, that's a really good question. Sex, it does include gender, but also, as I talked about before, gender identity, sexual orientation, all of those components fall under sex and are more broad than just gender. There must be a tangible employment action. So what does this mean? It means that there must be a significant change in employment status. So in order for a claim of quid pro quo sexual harassment to be actionable, there has to be an action, and it has to be a significant action. So if you're auditioning, you didn't get the part because you didn't agree to engage in sexual intercourse with somebody. You didn't get, or you got fired because you refused the offer to engage in sex, or whatever the offer is, kiss me. You get demoted. There has to be a significant employment action against you. So even if somebody propositions you in the quid pro quo manner, I will promote you if you kiss me. If you're not promoted, or if you're not demoted, whatever the threat is, then you have no action. There has to be an employment action for this to be a viable claim. So some examples. What is not actionable? If someone reduces your hours for 1 week, if there's discipline for being late 5 minutes, if you're assigned extra duties, if you downgrade a performance evaluation, all of those things the courts have found to not be a significant change in employment. Now, going back to the performance evaluation, if you get a low rating in performance evaluation and that impacts your employment in some way, then it may be actionable. Another thing that's not actionable is ambiguous statements. If you don't go out on a date with me, I don't know if I can be around you anymore. That's not actionable. There, again, it has to be a significant employment action. Another thing that we see in this area of law is a constructive discharge. So if you are propositioned with a quid pro quo situation where I'm asking you to do something, and if you don't, I'm going to do X to you. If the X is, I'm going to make your life hell, and I'm going to make coming to work so uncomfortable, I'm not going to take direct employment action against you. I'm not going to demote you. I'm not going to fire you. I'm just going to make it really rough for you to go to work, and you decide to resign, you may have a claim of a constructive discharge, whereas your employment was so intolerable, you could no longer work there. That can also be a basis to bring a quid pro quo claim. One act may be sufficient. And, let's talk about bisexual conduct. That's what the law refers to it. There's no quid pro quo for bisexual discrimination. So if someone is discriminating against men and women alike in a quid pro quo manner, There is no discrimination based on your sex. So you have no cause of action. It doesn't mean that you don't have a cause of action for harassment or another area of law, but you cannot prove that you were unlawfully discriminated against based on quid pro quo conduct. So that was quid pro quo. So let's talk about the other form of sexual harassment and discrimination, which is a hostile work environment. This can come in forms of verbal or physical. The elements to look for: number one, it's unwelcome, and you must indicate to your harasser that it is unwelcome. The harassment is based on sex. And the harassment is so severe or pervasive as to alter working conditions and create an abusive working environment. So I emphasized or. It could be severe or pervasive. So meaning there could be one act that could be so egregious as it will fall under the protections of the law. Or there could be several acts that are less egregious, but it happens so pervasively that it rises to the level of unlawful conduct. Courts will look at the totality of the circumstances. It's a very fact-based analysis. There's no one-size-fits-all. And I wanted to give you some examples to sort of contextualize what I'm saying. So what courts have found to not be severe: inappropriate comments, but just a few of them. A supervisor asks you to slow dance at the holiday party. Just a couple dinner invitations here or there. Someone's trying to date you. Email describing a woman's size of her breasts. These things have not been found to be actionable under the law. On the flip side, what the courts have found to be severe: supervisors made repeated remarks about an employee, calling her beautiful, telling her about his sexual fantasies, his desire to have sex with her, commenting on her physical appearance, asking her if she needed help changing out of her clothes. Those are examples of severe conduct. The victim need not be the intended recipient. So if you are in a workplace and the harassing conduct has permeated your direct work environment, you may also have a claim. Usually the court requires that you witness this. But you could have a cause of action even if you're not the intended victim. There's no physical harm that's required. Just the environment has to be hostile and abusive. The conduct need not be lewd acts or sexual advances. It's enough that the conduct discriminates a person solely because of his or her sex. Okay, so let's talk about the legal avenues. So there's two legal avenues. There's the federal legal avenue, which is through the Equal Employment Opportunity Commission, and there's also the state, which is the Department of Fair Employment and Housing. What I always recommend is that you utilize the state resources since you live in California. California is much more employee-friendly than most states, and certainly more employee-friendly and victim-friendly, if you will, than the federal government. Nonetheless, when you believe that you have been a victim of sexual harassment or discrimination, you may file a complaint with either the EEOC or the Department of Fair Employment and Housing. They share complaints. So if you file with the EEOC, a copy of your complaint will be provided to the Department of Fair Employment and Housing, and vice versa. We like the Department of Fair Employment and Housing better because you have 1 year to file a claim from the conduct. In the federal EEOC, you have 6 months. Under the EEOC, you can get unlimited damages, and all employers who do business in California are covered by the relevant law. Whereas under the federal government, you have to employ 15 or more employees. So what you would do is you would file a claim, they would conduct an investigation, and two things could happen. The agencies would either tell you that we didn't find enough evidence to substantiate a claim, but you can go to court if you want and sue. Or the agencies can say, we did in fact find enough evidence to substantiate your claim, and we are happy to take your claim for you, or you can go and sue on your own. Either way. You may, I don't want to get too technical with this, but you may sue your employer, and you may also have an individual claim against the harasser, herself or himself. So those are just some overviews of the legal avenues of where to file. And we're going to pass out, if we haven't already, there's the Actors Fund to put together a really great resource, sexual harassment resources, which will have all of the information to assist people with this, with filing a claim.
So now that we're all grounded in the same understanding of the law and working with the same definitions, we want to shift to looking at the effects of harassment and why it's important to access resources and support, and if it is possible, how to report and utilize the resources for you. So sexual harassment is a real form of sexual violence. There's a reason that it is against the law, as we just heard. And the effects can be far-reaching and can be long-lasting. There is no right way to respond if you are someone experiencing harassment or sexual harassment in the workplace. But it's important to understand and to know, and this slide really talks about some of the ways people are affected. People can have psychological duress. People experience low self-esteem. They can experience low productivity. There could be low morale. There's loss of creativity, loss of opportunity, financial costs. You don't feel like going to work. You're absent. You call out sick. You don't engage in your work life in the way that maybe you had formerly. There are consequences, or can be consequences, to your reputation, to your career. People experience family stress. There can be a likelihood of injury on the job. And there's the legal process that we just heard about. So what we're going to talk about now is sort of the ways to empower yourself as a worker in the world, a way that you can begin to know and take some of these resources and implement them into action if it's possible for you in a given situation. So what can members do? If you are a member that experiencing a situation, you might want to think of what we call as the 3 R's, which is that you have the option and the choice, if it makes sense for you in the context of your situation, to report it. You can use your business rep, which we're going to hear more about in a little bit from John. You can report that to a supervisor or manager. There are ways to look and understand your reporting chain that the union hopefully would begin to be able to help you understand in that particular work environment who's the reportable entity to let know that you're experiencing a problem. We do have the ability as people in the world of work to respond. If you felt that it was possible for you, you have the ability to tell the perpetrator, stop. What you're doing is offensive. It's not appropriate. I would like you to stop. If that makes sense for you in the context of yourself, right? You also have the ability, and we would encourage that you record the incidents. That let's see, we'll break down the slides a little bit more. So we talked about reporting. Sorry, I'm going to go to recording. So if you begin in which Dana talked about, you begin to start seeing work patterns or work history, right? We would encourage you to think about documenting that, to begin to record that, so that you would be able to detail the date, explain quickly what happened on a note, who was involved, was there any, what was said, what was your experience in that particular incident, when did it occur, what Where did it take place? What was the job? Who was the employer? Begin to write down some of the specific things that you're remembering in the here and now, right? If the situation was to continue down the line. It's important to know that you do have these options as a worker in the world to report, respond, and record. Those are empowering actions to take your environment into your own hands and begin to understand what your options are if things were to continue. We want to highlight and make sure that everybody knows here, and we know that we have some business reps, that harassment is not your fault, right? There is no circumstance that harassment is warranted or justified. And if you're experiencing harassment, it's wrong, and you should not be in that environment. That you have the right to address your feelings, even if the feelings are uncomfortable or unwarranted, you do have a possibility to express that. You can talk directly to the person, as we reviewed. Your employer is the legal responsible entity in these cases. It's the employer's responsibility to provide a safe work environment, free of harassment and discrimination, and to ensue safety in the work world. Your union is here, and we're going to hear about that in a minute, and you should be accessing and thinking of your union as a support and a partner in these world of work situations. And lastly, which we'll talk furthermore, you should know that there are community resources in your community. The Actors Fund is a community-based resource that is free and confidential. On our resource sheet, there are other entities that you know if you are in the middle of a situation and it is unclear what to do. There are people that you can talk to begin figuring out what's happening for me, what do I think I would want to be doing, what's the right step for me. There's support for you in the community. Briefly, as we all are moving towards this culture shift, or we hope that that's a culture shift, we have this slide in here because most of us can or may find ourselves in sort of a first responding situation, that you are in the pit and suddenly there's a colleague that's sharing with you an experience of harassment, or you're on the phone or in an audition and there is another union member that might be disclosing to you a situation that they found themselves in. And we wanted to highlight that, just to bring to consciousness and a mindfulness, that how it's hard to share your story if you've experienced this. It's hard to take a courageous step. And if you find yourself in this situation hearing from a colleague, we want to just highlight some of the ways that some options you have to be a professional support, right? If somebody is sharing, it's important to listen to their story. It can be helpful to repeat back what you're hearing, right? So you're saying you were in the pit in the show of blah, 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 right? Repeating back what you're saying, making sure that you're getting the story right, right? You want to be aware of privacy, right? And confidentiality. Are they sharing the story with you in a crowded room with tons of other people? Can you say, hey, I'm wondering if we can go over here to the hall where we might create a more confidential space and the person has more of a possibility to share what's going on. We want to allow the person time to come to the decision of what they would like to do. They may be saying to you, I need to tell this to somebody, but please do not say anything to anybody, right? And we need to allow people to come to their own interpersonal decisions on their own journey, right, of this experience. We do not want to pressure a person into revealing if they're not ready to reveal. We want to listen and hear and support. We want to focus on the facts, and we want to seek clarity if we're not understanding what they're sharing with us. We want to keep our own personal stories and our own bias at bay. So if someone is sharing with you, you don't want to say, oh my gosh, I was on that show too. Totally happened to me. This is what I did, right? That can be less helpful, right? We want to focus on our colleague and our friend. And most important, we will hope that all of you walk away with today and you spread the news with a lot of people that there are free and confidential supports and resources that they need to activate and can use. And you might need to act as a conduit to say, hey, do you want to call together? Hey, there's this place called the Actors Fund. Do you know their number? How can we help you get connected to resources? So, before we shift over to the union, just as some bullet points, what you can do to be empowered and to know. Know your rights as an employee. If you can, know who your employer is for every gig. Who is the employer? Know your employer's policy and their chain of command, if it's possible. Know how to use the union, which we're going to talk about next. Know what you can say if you find yourself in a harassing situation. Do you know what you can say and how you would respond to the best of your ability? And know what you can say if you witness harassment. We were all in this creative community together, and if you're witnessing a situation, I think in shifting the culture and moving it forward, the hope is we would all be there together, working together to support one another to help our culture shift. And lastly for this, just to know that you do have support and you should not be suffering in silence. You do not need to be holding it in all alone. And the best bet is to talk and reach out for help. So we're going to shift and hear from John a little bit more specifically about how Local 47's thoughts and ideas in this issue.
Excellent.
Yeah.
Thank you. So, we embarked on this effort as a kind of the effect of what had really started with the whole Harvey Weinstein phenomenon, and looking at our brothers and sister unions and SAG-AFTRA and DGA and some of the others, how they really started to try and kind of create an environment for this conversation. And so this is really the beginning of that for us. We think from here we'll take it more into the workplace and try and foster more of a discussion with our own members. But as a response to that, our executive board put out a statement towards the end of last year, which was sent out to all of our members. And what you see before you is kind of a summary of it. It's a fairly lengthy statement, but the board adopted a zero tolerance policy towards sexual harassment and wanted to ensure that our members knew that, and also invited members to engage with the union in this conversation to see how best we can fit in into this area and support their concerns and their issues. Moving forward in that, we set up, I guess we're announcing today, which will get out in a more broad way through email and through our newsletter, a confidential hotline. So members can call confidentially and file a complaint with the union. I think because of the precariousness of the work that our members do on a freelance basis, I think that most of the concerns will be confidential, will have to be, because we'll need to figure out how best to approach them in a way that doesn't jeopardize their employment. We are also going to empower our business reps to be able to be the voice and face of the union in the workplace, to make them comfortable, to be able to receive those concerns and help members navigate the process with the union support. We're at the very beginning stage, so working with the Actors Fund and legal counsel figure out the best way to move forward. And that we've also set up a reporting system online, so members can report their concerns through our website. And we have such a varied employment landscape, and what our members do is so complex just to show up and perform. And just to think that having those challenges, but on top of those, having to wrestle with harassment on the job, we want to make sure that we do everything we can to eliminate that aspect of any additional complexity. So, we are really thankful that Actors Fund has helped us with this, with this really the beginning of this effort for us. And as we learn how best to support our members, as we hear from them, we'll be able to modify our approach and kind of enhance it.
Great. Yeah. And the Actors Fund is really excited to continue our work and our conversation with the union. And that sort of bleeds into our next slide of how people should really be thinking about using the Actors Fund. The Actors Fund is a free and confidential human services organization that's national in scope. So if you were to find yourself working in any of the states in the United States, you have regional access to where you might find yourself working. So in Los Angeles, our offices are in the Mid-Wilshire district. We also have offices in Burbank. And you should know that you can access the Actors Fund at any time if you have any of these related concerns about your work environment, but also a myriad of any other related topics and issues. So we provide supportive counseling and support related to sexual harassment. We would hear what was happening with you. We have no agenda. We're licensed clinical social workers. We would hear what was going on for you. We would begin to walk and talk through, where are you at? What would you like to be doing? We would want to make sure that everybody understands the resources that are available to them legally, as well as the reporting systems, which we learned a little bit about today. We would want them to make sure they're tending to their own mental health well-being, right, and continue to flourish as a musician in their career for as long as they would choose to do so. That would be our objective as we work with people, right? In a broader sense, the Actors Fund has 4 buckets of service. We have a career center, we have a health insurance resource center, we have our whole social services wedge, as well as our health insurance wedge. So if you don't know about us, we hope you go online, you click through and know what resources are available to you. We love to hear from the entertainment industry community. We have tons of free groups and workshops, all available to musicians and anybody in the creative community, right? Lastly, our last pitch for us all, right, is we all contribute every day to creating healthy work life and healthy work life environments. And so this is just a reminder to us all, right, that every time we work into the world of work, we are hoping to respect our colleagues, and we are welcoming all diversity, knowing that all of us in our richness of our lives bring context and a wonderful fabric to the art that we're creating, right? We are hoping all of us can be aware of our language, of our body language, our communication, our emailing, our texting, all the ways in today's society we are interfacing with each other. We all have to be aware and to be conscious and mindful of what we're putting out, right, to each other. We are creating our community, right? It goes without saying, but to just say, we need to avoid comments that could be demeaning, behavior that could be demeaning. We need to be aware of insulting comments, unintended insulting comments, right? We need to be mindful of conscious of what we're saying. And most of all of us together have the ability to create civility and respect and to work towards creating a safe and a beautiful work environment in the music industry, which is to do what you do best, right? Which is to create beautiful art and music and continue to thrive in your creative self. So that's sort of the end of our formal presentation. We're going to move to questions. So if people had written any questions down on your card, we're happy to talk about questions that may came up in the presentation. If you have, this is a moment, if you want to think about how much you learned, you might want to rate yourself if you went up a notch or two, just to be able to think about what you gained. And just a big shout out for all of you for carving out the time in your own lives to join the conversation and for us all to keep the conversation going. So does anybody have a question, or how should we? Yes.
I have 2 questions. One is general. In going through some of this, so many of these situations are he said, she said, or she said, or whatever, And so, yes, you can document it, but when it comes down to it, if nobody else saw it, and my experience is harassers are incredibly clever because they know that what they're doing isn't right, of doing things where it's really hard for other people to report or see or things like that. So is it even worth coming forward if it's a private thing that no one else can corroborate?
Well, I can answer that from a legal perspective, that I absolutely think that it's worth coming forward. It doesn't mean it's not going to be difficult, and that it doesn't mean that the victim is going to be scrutinized. The victim's conduct will be scrutinized as well. However, what Tina was saying is that we need, in order to make change, we all need to engage in conduct that will lend itself to that change. And unfortunately, some of the burden is going to be on the victims, and the victims are going to have to start coming forward, no matter how difficult the hill seems to be to climb. Hopefully there's people out there that will help them. And hopefully we believe in our justice system that the credibility of the victim will win over the testimony of the perpetrator.
Mm-hmm.
And I don't know if you have a
Yeah.
different non-legal response.
I mean, I think that's right. I think what I also hear a little bit in what you're saying is that it's hard. It's hard to feel like anything is actually going to change. And I think that's real. I think that's very real. And the hopeful side, right, of me in the professional world of work, hopeful side, realizes that if we don't, it's never going to change. And so, everyone's going to do the best they can. I think the other thing that I hear in that a little bit is that, the more these stories come out and perhaps in your communities too, people really seem to know the hot people, right? There's sort of there's culture in the groups that we work in, and people know people that are going to make people vulnerable to this. And I do think that's where the entertainment industry as a community of people that work so closely together have to come together to protect each other, right? If you happen to know that somebody's going to be working with somebody that you've heard a lot of things about, I hope we would all lend ourselves in that way to say, you might need to be a little careful, when you go into that audition room, or can you bring a colleague? We have to start thinking of strategies, right, to make each other less vulnerable if we know we need to be on notice for certain professional people.
Did you have another question?
I did, but in this, I won't go into the whole story, but in the scenario that I was talking to you about before, if a union official, the secretary of the union, and if it was a well-known fact, demanded that young women kiss him before he gives them their union card, does this fall under the category of illegal behavior?
It could. I hate to give
from what you were saying, here he is, somebody in authority, and the threat was, if you don't kiss me, you don't get a union card. This was a long time ago, by the way.
Is this some made-up scenario? Or
That's what happened to me when I joined the Boston
That's back
Local.
when we knew this as life.
Yes. This was quite a while ago. This was decades ago. But, because I'm just curious, because it was after 1964. So, was that illegal behavior?
I don't know,
Yeah,
and
okay.
it would really depend. I don't know if it would.
Depends on what, the circumstances, or?
Yeah, it depends on the circumstances. You're a member of. You're trying to get membership so
Right.
you can get employed.
Right,
Right.
yeah.
So what we're talking about today is more specific to an employment relationship
see.
and not a member union relationship. So I don't believe it would be covered for those reasons. But I have not researched that particular scenario, so I don't want to opine on it.
Looking back on it, if that happened today, there were so many women talking about this.
I would say, no, give me my card.
Well, see, it didn't even occur to us to say that. It's just incredible. But anyway, I almost wonder, if it happened in today's world, if it could be like a class action suit or something. I knew 20 women. We talked about it God, what do you do when you get your union card? Oh my God, it was a thing.
Well, and I think what we do know, right, culture starts from the top down. So, it's really interesting that what you're highlighting, this was a leader,
Yes.
right? This was a leader, all of the power conversations that we talked about come into play,
Yeah.
right? And I don't know, I guess my hope, right, if that were happening today, those women would come together and
Right.
put pressure on the people, on the leadership, right, to say, this isn't
Yeah, this is
acceptable
horrible.
anymore, right?
That's what bothers me the most. It didn't even occur to us.
It's a different time, yeah.
Well, actually, she had her hand up, and then we'll
Yes.
come over here, yeah.
Okay, so you're starting to talk about culture, and I guess I have a little bit of a different question. You're talking about what happens to individuals, right? Things that happen. But what if you're a person that, and I've seen some people like point some of these situations out on Facebook, and I've even like mentioning certain people's names. I said, don't do that, you know. But what if you're a person that is made uncomfortable, or you sense certain things, like let's say in an orchestra, and either it's the contractor or the conductor, and you notice this pattern of them using the people, the women in this case, as their dating pool.
Mm-hmm.
How are you addressing things like that? You know, I won't stand up and say, you know, I'm really uncomfortable that you're doing this, because it makes
Yeah.
me feel like I'm going to be part of, you know,
Yeah.
or I have to play that game. So I mean, there's lots of like subtle. My feeling is, especially if you're a smart woman, and let's face it, a lot of women in music are smart. You know, you have to be smart to play an instrument. If you're smart and you're attractive, or even whatever the situation is, things are much more subtle than, you know, the Harvey Weinstein come up to my hotel room, and, you know.
Mm-hmm.
It's a culture. It's how are you changing the culture? And I'll tell you, a lot of other women, I remember especially, you know, over the years, I've heard lots of women say things like this to me. He'll hire you, he likes pretty women.
Mm-hmm.
Right? That automatically makes me uncomfortable.
Mm-hmm. So your I'm sorry. So your question, or you're just
My
making sort of a
impression
statement?
is,
Yeah, I
how
think
are you
it's yeah.
addressing, especially on the legal side, you know, how are you looking at corporate culture?
I like to just say something. I mean, I think one of the challenges that we have as a union, so this happens a lot in a lot of orchestras, and now I think it's starting to be looked at differently. I think before, like boards of directors, you look at what happened at the Met with the conductor, and how the board suppressed a lot, or knew, or kind of heard, but didn't want to know. And I think now, as the culture changes, that we need to better inform ourselves how to deal with that. You know, would it be appropriate for the union, I don't know, to contact the management and say, you know, we have an issue with this conductor. This is what we're hearing. You know, maybe that's one approach. I mean, there may be other approaches. And it wouldn't necessarily come from the women, because they may not feel comfortable. They may not want the union necessarily to get involved. I'm not sure what the dynamic is.
So I'm just wondering, is that a definition? I mean,
Is that harassment?
Yeah, it's like if you're a woman on the outside, I mean, I'm not interested in bringing any kind of action, but if you're a person on the outside looking at this, I still feel like that is it's inappropriate behavior in the workplace. I've felt this for years. Two conductors that I'm thinking about have both been fired, and this is after years, you know, that I've worked with of this kind of behavior. Or maybe it is because of this shift. And I remember telling certain board members, female board members of these particular orchestras, and they just kind of like, oh, that's, you know, all the time.
You know how he is.
Yeah, you know how he is. Yeah.
So a question for the
Yes.
lawyer on the panel, I would ask, if some of these women were being promoted and others were not, would that be a sexual harassment issue? Saying the ones that were engaging in this dating pool? and the
Because
ones
they
that
were
weren't?
dating.
Right.
Well, there could potentially be. So it could potentially be for the women who are in the dating pool. You could find the quid pro quo, unlawful conduct, which is, I will give you this benefit if you date me. So that could be there. For the women who are sort of in the periphery and see this going on and are uncomfortable by it, it may not rise to a viable cause of action because there has to be a significant impact on your employment. And being uncomfortable by what you may perceive as a lot of consensual dating, you don't know if there's this quid pro quo going on underneath. There's what I'm hearing from you is there may not be evidence that it has significantly impacted your environment that would rise to a level of a legal cause of action.
No, I understand, and you're coming from that point of view, but I still find that to be an interesting angle to all of this. In terms of, like what you're saying, you know, we're there to make art and to make beautiful music, and it just, I don't know.
We
I
had,
think it affects it, you know.
And I guess I wonder, I'm not sure if this would begin to happen or not, but you know, I have a lot of wonderment if women that are in the orchestra that you're talking about start even anonymously contacting their business rep or contacting whatever that chain of command is to say, you know, I just want to let you know that this conductor, right? I'm wondering if that puts other people on notice that are in a position of power to help reshape that behavior of that conductor, right? That they then would begin to feel some onus to check in with that conductor and say, hey, I just want to let you know we've gotten a couple calls. I'm kind of curious, right? I don't know if that's how it will ever play out, but I do know that the only way it's going to shift is people start kind of in a way that's safe for them, right? And that could be, anonymously, to check in with people who have the power over that person, right? To say, I'm not sure, right? And they're going to call and say, what's going on? I mean, I don't know. Yeah, I mean, what you're bringing up is a very delicate way that these work networks
It's just-
function.
I'm interested in that.
Yeah.
You know.
we had another question here, and then Judy,
Well,
or comment.
more of a comment. My name is Alex Sanchez. I'm a business agent for the Teamsters, private sector. We must do better. And the way we do better is to start looking at our workplaces and make the decision, no, this is not right. I'm seeing a lot of youth movement. I'm seeing a lot of changes in the landscape, and it makes me feel good because I see changes coming. I see a lot of young people. It's so unfortunate to hear all these stories of what happened and what was let go, but like your union itself, our union is zero tolerance, and even if it's just perception, a lot of the times, yes, you could be going to play or you could be going to work every day, and maybe it doesn't, there's a dating pool going on, but it changes the way you feel when you're going to work. It's impacting you, and like all what you had listed, it changes, you know, your physical, mental. It gets to a point where your workplace is uncomfortable. So it might not go to the level of legal,
Yeah.
but if you feel something and you feel something is wrong, use every avenue that you can to report it. And maybe somewhere along the line, somebody will be there to help you out. But we have to consistently change. We need to be better. For the male species, we need to be better. I have 3 daughters, and I would hate for them to go through any little thing like that. So, yeah, just if you feel uncomfortable in any situation, the first thing you should do is report it to your business rep. And then your business rep, having the experience, will be able to know whether it goes forward, whether you go to EEOC or whatever. But just don't stay silent.
I
Thank you
think
for coming.
it's a good point to emphasize that you would feel uncomfortable in the situation that you explained to us. Just because it's not illegal doesn't mean it's right, and doesn't mean that we shouldn't collectively do something about it.
A lot of people just don't feel empowered, you know, a lot of people just,
Right.
they just accept the situation, and to me, it's the culture that has to shift, you
It's
know,
such a
and-
fear-based industry in
Yeah.
the first place.
Judy had her hand up.
Gosh, Alex, I'm Judy Chilligan, I'm on the executive board here, and I'm really proud to be a union member right now, having you here. Thank you for being here, and thanks for doing this after sun. You've helped me through the years. So, John, let me ask you a couple questions as far as chain of command and framework. So, I'd love to also at some point ask the business reps what kind of calls they've ever gotten, you know, if any of this has come to you. So we have a hotline now, right? Okay, so who answers the hotline?
So all the calls from the hotline will be routed through the president's office.
So will it be to a recording? Will people get a recording
Right, so,
at first?
yeah, so they'll get a recorded message where they can leave a voicemail, And that will be picked up by my office, which will then be reviewed and kind of interact with the complaint, with the complainant, I think is the word. And then assess, whether if it's a collective bargaining agreement issue, how we address it, if it's a freelance, studio kind of environment, try and figure out what the right avenue to help the member. It's kind of how we would take those in. What we want to do with the business reps is also allow that, because some members will feel more comfortable calling a rep that they have a relationship with than an anonymous phone call to the president's office. So we want to also empower them to be able to have confidential conversations, because that may be a better avenue. Members may want to call someone they know. Could be members of the executive board. Someone may want to come to one of. By the way, we have 3 board members here. Bonnie Janowski, Vivian Wolf, and Judy Chilling. And so they may want to come to the board, and so we also want to prepare the board for those kind of conversations.
And so the recording says, we are the hotline if you've experienced any kind of harassment. What will the recording say?
Basically, it's a basic voicemail.
Yeah,
Linda's
say,
helped set it
yeah,
up.
This
Is
is
it
the
operating yet?
harassment hotline. Yes, but the message needs to be updated.
Okay, and can we get guidance from your experience in hotlines as to maybe what that should say, that outgoing message should say? Do you-
Oh, sure, we
Mhm.
can
We'll
work
work
with you
with you.
guys,
Okay.
of course.
Okay,
Yeah.
now, and we have an HR person
Mhm.
who I believe would not be connected to the members. Our HR person is just for
For employees,
staff,
right.
right, for just employees.
Right.
Let's see.
I have a quick question for Actors Fund. You have a hotline too?
We do
No,
not,
You don't?
no,
Okay, so you have a social worker that members or people
Yeah.
are routed to?
yeah.
Okay, so they don't leave a voicemail, they interact with?
Well,
someone.
they do leave a voicemail
Okay.
just because of the volume of
Okay,
calls.
okay,
And then those calls are responded to within a couple of hours to take those calls.
Okay.
Yeah.
I was thinking that maybe part of the outgoing message might be that there is this number at the Actors Fund, which also is somehow, however, whatever wording, just so
Sure.
that there would also be at least one extra piece of information on the outgoing message.
The idea is to also include the website and say you can find additional resources here as well with the message.
But if our resources are the business reps, I would think that the Actors Fund is really the professionals, and the great source or a great source. But also to leave that in the outgoing message as well as, either call your business rep or maybe they don't want to call anybody and just say, this is happening at the Pasadena Symphony and it's happening now, and I know 5 people this has happened to,
Mhm.
but I'm not telling you who this is. Then we have to figure out a process and a procedure. The business rep who handles the person,
The CBA, right,
and
Right.
the CBA, would be involved in the discussion with you, that kind of thing.
right,
Anyway, I just want to
Right.
make sure that we get, this is fantastic that we're launching this hotline, that we're having this today, and that we just get the process, so, the numbers don't get buried and the
Right.
call is really both welcoming and, gives us the opportunity to collect as much information as
Right.
possible.
Right.
And then I would ask the business reps through the years, Diane, you've been here for a very long time, and do people call about that stuff? Can I ask? Can I ask?
should
You don't have to
should they
say-
respond?
I'm just saying, I'm just saying.
One member come into my office.
There was no
All those
names.
years,
There was no
yes.
names.
No names, no names.
Yeah, no, I'm just saying that for us, I was grabbed on the way in, as a young musician in town, on the way into the pit in the second act at the Schubert Theater. And part of me, and I was, I was subbing, so I really had to do a great job. And some of me remembers it as, did it really happen? I thought it happened, and now I have to go play the second act and play my ass off. And I'm of that generation where we did call it life, and we did, so I'm, of course, thrilled. you know, this is the conductor thing is, you know, forever, and, you know, you wouldn't go to your contractor at all.
No.
Yeah.
So, you know, it's great, and I mean, and it's changing and generational, and it's wonderful. So thank you all, thank you, it's great.
Thank you.
Well, that's a good idea.
Yeah, so if we can, because we wanna really make it a good outgoing message, so people,
Right.
you know, really.
Yeah, we wanted to have something set up by this meeting, but we do want to fine tune it and make it more comfortable for people to be able to interact with the voice message. Okay, any other questions? I have a question. So, filing a complaint with the EEOC, how long does that normally take? Like, how long can that take, that process, for them to do the investigation and let you know?
Unfortunately, depending on how busy they are in their backlog, it could take months.
Months?
Yeah.
But not years?
The hope is that it won't take years.
Okay.
I haven't seen years, I've seen months.
Okay. I have another question. So, most of our collective bargaining agreements have language that say, you know, the employer will comply with all state and federal laws, which includes, you know, the law about discrimination and all of that. If we have a complaint from a member who's part of an orchestra, that's you know, they're an employee of an orchestra. What is the role, in your view, I have my own opinion on this, what is the role of the union at that point of contact as far as the intake? We get the complaint, we acknowledge that there's an issue. Do we then guide the member to the HR department of the of the employer and monitor that process? Or do we directly take it on and go to the employer ourselves? And how would you counsel?
Well, I think, and I'll answer that in part by pulling a bit from what Tina says, is that the individual could be the guide. Because sometimes members don't want to make a complaint.
Right.
And so for the union to just take charge may not create a good situation. So what I would suggest is that we work with the member. And make sure that the member is comfortable in what we're doing with the member. The law requires that all employers in California must have a policy and a procedure to deal with these issues. And so information is power, so I think the union can certainly take the first step of getting that policy and procedure and informing the employee of the employee's rights. And then, or the member, I should say, and then assisting the member in going through that procedure with HR. You mentioned that there could be a clause in the contract. The union can certainly file a grievance. Normally in the contracts that I'm familiar with, the grievance, the non-discrimination clause doesn't cover the same breadth as the law does. So even though you file a grievance, I think we should also educate our members and let them know about filing a claim with an agency. But they will have to go through the employer's procedures first and exhaust that before they file.
Can the union file the EEOC complaint, or does the member have to file it? Can we do it for them, or?
I don't know. I've never had a union who's filed on behalf of their members, so I don't know the outcome of that. I do believe that the individual has to be involved. So
Right, that's what I
based
figured.
on that, the
has to
members.
file.
Okay.
That's what I figured.
Thank you.
Right, okay.
Okay.
The same with some of the fair standards of employment claim, DLSE claims.
Okay, they have to
Right.
file on their.
Right. Okay, those are my questions.
Well, then I'll make another comment. Just going back on that. So grievance through the CBA, your remedy is usually make sure it doesn't happen again, et cetera, et cetera. But there's no financial remedy. We usually tell everybody to document paper trail, start the union procedure, but then go through the EEOC, and then once that's done, they send you a paper that gives you the right to sue. And then if you wanna go against whoever you're going for pain and suffering, financials, that's the only way you're gonna do it. Cause a union contract only allows you, it's not gonna get you any type of money or financial settlement or anything. So, but we always tell everybody, like it was said before, document everything. That your notes are probably gonna be used in court, so make sure you document. everything you possibly can, who, what, when, where, why, times everything. Exhaust all avenues through the union grievances, talk to HR, do everything you have to do. So when you go through the litigation part, you said, look, I exhausted all my resources here, and this was my only option.
Right.
Under the contract, that you could get some financial remedy. So if you were demoted because you refused to acquiesce to a favor, you could get made whole. But you're right in that you don't have the same access to the bigger like damages, if you will, the finances that come with finding that you were wronged unlawfully.
Right.
And I think just to highlight too, and piggybacking on something you had said, is that what we know is that 75% of people do not report in a legal pathway, right? So the business reps and the unions, I think it's just important to help the member, right, know that they might go through a whole process of trying to figure out what they want to do. And that may not equal filing. It may, right, but it may not. And we want to really empower victims, empower people to be making their own choices. That's the best for them in the context of their life.
Right. Keith?
Yeah, I just wanted to point out too that, there may be union members who are the accused, not just the people who experienced it. And so if you're in that situation, you have someone who's been part of the problem and they're actually interested in getting into some sort of therapy or treatment to try to not be part of the problem anymore, you can send them to the Actors Fund too, and we'll try to hook them up with treatment.
Fantastic. Thanks. Any other questions? Judy?
I was interested in what Dana said about getting language into the CBA. Is that being done?
Not getting language in, but there may be language in. So a lot of contracts that I deal with have a non-discrimination clause. And it's just a very general statement that the employer will not discriminate you based on the list of protected
Yeah,
categories.
We have that. It's pretty standard in our company.
That's what is referred to in a sexual harassment case.
You would be able to file a grievance.
You could file a grievance, but the arbitrator doesn't have the authority to make a decision on the law. The arbitrator can just interpret the contract, and so I don't think it's the proper avenue to bring a claim of sexual harassment. You could, but my advice would be is to first follow the policies and procedures through the employer, and then the proper avenue to bring a claim would be through one of the agencies that we described, either the federal or the state.
Yeah, I didn't understand when you said.
Okay,
talked
sorry.
about discrimination language in the contract. I thought there's now some new language that we should be thinking about. Yeah, no, I
Or
understand
existing.
that, yeah. And if the harasser is a member and comes to us to be defended, do we have to do that, or do we have to, how does that?
That's when the lawyer comes in.
Well, yeah, so-
Years some pretty
yeah.
stinky to-dos having to defend a stinky.
You have to, duty of fair representation.
Right.
Well,
Duty of fair
so yeah,
representation,
there's a
that's
duty
it.
of fair representation, which doesn't mean you have to take the case. What it means is that you have to do your due diligence to make a decision to take the case or not that is not based in a discriminatory fashion. It's not arbitrary or capricious, but that there's some sort of legitimate rationale for not taking the case. Now, I have defended accused harassers, union members through a contract, and they were fired because it was alleged that they had engaged in this unlawful conduct, and the employer had done a full investigation and substantiated the allegations. And then the union brought the case to me, and it wasn't this union, sorry, and we analyzed it, and we found
You're still new.
we found that the allegations were not substantiated, that there was another motivation to attack the alleged harasser, and we ultimately prevailed at arbitration. And the arbitrator found that there was no unlawful conduct that happened and ordered him to get his job back. So we also can't just assume if there's an allegation that it's
Right.
true or not, and every member deserves the due diligence review of what their case is.
Right. Great. Any other questions? Well, I want to thank Tina and Dana for this amazing presentation, all the work that led into it, and round of applause for being here.